Kenyans, alongside my colleague, Ms. Marion Abuya.
Rashid Mwananchi Sharif. We can proceed. Founder of the Executive Committee Member for Finance, Kisumu County, that is the first respondent. The County Secretary, that is the fourth respondent. The Chief Finance Officer, the second respondent, guilty of contempt of court after they had failed to comply with an order of mandamus issued by this court on the 5th of June this year that compelled them to pay the ex parte applicant a sum of Kenya shillings 21,000 and 16,710 and 70 cents plus cost, assessed at Kenya shillings 130,000. It is not worthy that the conviction of the first, second, and second and fourth respondents was done in the presence of their counsel, one Ms. Odinga, who then requested for 1 week to enable her client settle the judgment sum plus cost. Sentence was then scheduled on the 26th of September this year. On that day, the contemners did not attend court for purposes of sentencing, and the advocate, Ms. Ruto, indicated that the second and the fourth respondents were away on official duties. While the first respondent was said to have been taken ill and was also said to have been appearing virtually, Ms. Ruto then sought the court's lenience, and despite opposition by Mr. Manyora counsel for the ex parte applicant, sentencing was deferred to the 17th of October this year. On the 17th of October, the contemners were absent yet again. No explanation was tendered about their failure to appear before the court for sentencing. The sentencing was then rescheduled by the court to the 24th of October, when only the second respondent attended court and was duly sentenced. On the 25th of October, the respondents have filed two applications, one by the Office of the County Attorney and one by Mrs. Obiero and Associate. A notice of withdrawal dated the 25th of October was later filed in respect of the application filed by the Office of the County Attorney. The same was duly adopted as an order of this court. Directions were then given on the application filed by Mrs. Obiero and Associate. On the 28th of October, when the surviving application came up for hearing inter partes, this court was informed that the Office of the County Attorney had filed another application on a Sunday, and parties proceeded to make oral application on both applications simultaneously. In the application of the 25th of October, the orders sought were for certification of the same as urgent, that there be a stay of execution of the sentencing orders delivered on the 24th of October against the Chief Officer Finance in the County Government of Kisumu, pending hearing and determination of that application, that the court do grant leave to the first and second intended interested parties to be enjoined in the suitors interested parties in person. That the planned sentencing of the first respondent on the 28th of October be stayed pending hearing and determination of the application, that the court be pleased to review or set aside the sentence order against the Chief Officer, Finance, County Government of Kisumu 1, Mr. Martin Okode Opio, and substitute it with appropriate reliefs. In the second application dated the 27th of October, it sought the following orders: certification of the application as urgent, that the court be pleased to review or set aside its orders made on the 19th of September convicting the contemners, that the court be pleased to review or set aside the orders of the 24th of October sentencing the second respondent, and that the court be pleased to make a finding that the contemners have fully purged the contempt, that the court be pleased to arrest or hold in abeyance the sentencing of the first respondent that was scheduled to happen yesterday, and that the Chief Finance Officer be released from prison on terms as the court in its sole discretion may determine. At the ex parte hearing, interim orders in terms of prayers number 5 and 6 be allowed, and that cost will be provided through. I do note that that application filed on a Sunday did not go before the duty judge, who was my sister Justice Aburili yesterday, but surprisingly found its way into this file. I have these were the submissions of the councils. Prior to the making of the submission, the court was informed by Mr. Onyango that a consent order had been entered on the 25th of October. This fact was confirmed by Mr. Manyora, counsel for the ex parte applicant. It was submitted by Mr. Onyango that a party found guilty of contempt can approach a court for mercy. He submitted that the contemners have, by entering a consent order, purged their contempt. Therefore, the court should be pleased to review the orders of conviction by setting them aside altogether, and thereafter hold its hands against sentencing the first respondent, and further be pleased to release the second respondent from custody. It was submitted that the contemners were signatories to the witness account of the county government of Kisumu, and that the orders of this court will in essence grind the functions of the county government to a halt. Mr. Odinga and Ms. Odor made submissions that were parimatia to the ones made by Mr. Onyango. Ms. Odor made an apology for her absence, for her failure to come to court in time, which prompted this court to go looking for her. That is on the 24th of October. Mr. Manyora submitted that he was principally not opposed to the application, save that he called for deferment of the sentencing of the first respondent to the 11th of October, as payment per the consent, the first payment per the consent order was to be done on the 8th of November. On rejoinder, Mr. Onyango submitted that this court ought not to be used as a tool for effecting execution on the part of the ex parte applicant. This court has considered the submissions of counsels for the parties, and the issues that emerge for dissemination are as follows: whether this court should enjoin the interested parties in this application in their personal capacity, whether this court should set aside the orders of conviction made on the 19th of September this year, whether this court should refrain from sentencing the first respondent, whether this court should revise the custodial sentence of the second respondent. This court notes that no submissions were made by the applicant's advocates on the issue of gender. this court notes that the intended interested parties are already parties in this suit. Wherefore, it does not see the need of enjoining them yet again in their personal capacity. In any event, they are in this case as employees of the county government of Kisumu and not in their personal capacity. So that prayer falls. On whether this court should set aside the conviction order made on the 19th of September this year, I note that no grounds have been adduced for setting aside or for the review of this order. I refer parties to Order 45 Rule 1. You will read it for yourself. There has been no discovery of any new or important matter that was not within the knowledge of the contemners when this court made its orders on the 19th of September this year. It is instructive to note that Ms. Odur, counsel for the respondents, was present when the order was made. No authorities have been cited for review that is compliant with Order 45. The Supreme Court of Kenya in the case of Okongo Ventures Limited versus Beer Tosha Distributors and others, is 2023 EK LR rendered itself on when a court can set aside its own orders. And this is what the Supreme Court said. That can only happen when the judgment or ruling or order was obtained through fraud, deceit, or misrepresentation of facts, or where the judgment, ruling, or order was a nullity by virtue of being made by a court which was not competent, or where the court was misled into giving judgment, ruling, or order under the belief that parties had consented, or where the judgment, ruling, order was rendered on the basis of a repealed law or as a result of a deliberate concealment of a statutory provision. None of the above conditions exist in this case. This court had the competency when it made the impugned orders. On whether this court ought to refrain itself from sentencing the first respondent, I do find that prayer absurd. A conviction for contempt of court mutates a civil case to acquire penal consequences as envisaged in criminal jurisprudence. A court of law cannot, upon making a conviction, refrain from sentencing. Whereas the Contempt of Court Act was declared unconstitutional in the case of Kenya Human Rights Commission versus AG, that act set out the punishment for contempt, which was set as a custodial term of up to 6 months and a fine of Kenya shillings up to 200,000, or either or both. On the question of whether this court ought to release the second respondent, I do note that there has been concerted efforts by the contemners to purge the contempt, wherefore this court is inclined to do a review. On the balance, the prayers for setting aside a review of the conviction are disallowed. This first contemner is hereby sentenced to pay a fine of Kenya shillings 200,000 and serve an imprisonment term of 2 months. In the event of default of payment of a fine, the first contemner shall serve a custodial term of 3 months. The sentence of 2 months is hereby suspended until the 19th of December this year. The default sentence shall not be suspended. The sentence against the second respondent is also reduced to a period of 2 months, and the same shall be suspended until the 19th of December. The second respondent shall be released forthwith unless otherwise fully held. There are no orders as to cost.
Thank you, my lady. My name, as you know, is George Okongo, the County Executive Committee for Finance, Economic Planning and ICT Services. And my lady, I thank you from my advocate, the county agent, thanking you and his court for what is clearly an understanding, your tight understanding of the circumstances that we go through trying to manage public finances in these very difficult times. primarily to be an advocate for my own case, that these things find us in the spaces where we occupy, not because of our own desires to make mistakes or his own accord, but because of the circumstances under which we work. And so I want to thank you for being considerate, both myself and my colleague, and also assuring that of our cooperation with the ruling that you have made. Thank you very much.